Hello there, ladies and gentlemen. My name is Lisa Cleary and I am a Senior Director in ICMA's Legal Department. Today, I want to take you through some of the headline issues which ICMA has been working on from a repo and collateral perspective. First up, the ICMA GMRA legal opinion exercise. Taking into account the schedule for Brexit, we adopted a phased approach to updating the legal opinions in 2019. As you may recall, we started work on the opinions in December with a publication in April the following year. In the first phase, we updated the non-EU jurisdictions for publication in April 2019. We then commissioned the update of the EU member state opinions, which have been drip-fed onto our website as they became available. In 2020, we've returned to the usual timetable, and the 2020 updates to the ICMA GMRA legal opinions are expected to be published week commencing the 13th of April. We are pleased to note the addition of Argentina as a new jurisdiction covered by the suite of opinions. Interim updates to some of the opinions may be necessary once it's clear what terms will apply at the end of the Brexit transition period. We will keep the membership informed of any developments. You will by now, I'm sure, be aware that the support of the ERCC committee, ICMA discontinued coverage of the GMRA 1995 in the GMRA legal opinions from 2019 onwards. The opinions will continue to cover the GMRA 1995 as amended by the Amendment Agreement and the GMRA 1995 as amended by the 2011 GMRA Protocol, with certain elections being made. But to be clear, the opinions will not cover the GMRA 1995 annexes to the GMRA 1995 or amendments to the core provisions documentation. ICMA is keen to encourage members to move to the latest version of the GMRA, and if there's anything we can do to assist you with this, including guidance in relation to the use of the 2011 GMRA Protocol, please do not hesitate to get in contact. As always, the opinions are based on a pro forma opinion with standardised counterparty coverage. We do encourage members to provide us with feedback on the form and scope of the opinions so that we can consider any comments as we prepare for the next update. So moving to the next slide, the next topic on which ICMA has done extensive work is SFTR. My colleague Alex Westphal will speak to the technical details of SFTR in his presentation. But there are two standardised legal documents which we have developed to assist users in complying with SFTR. The first was published some time ago, but since SFTR goes live in July this year, it may be worth highlighting. Article 15 of the SFTR requires a party to an SFT to inform a collateral provider of the risks and consequences of granting consent to a right of use or entering into a title transfer arrangement, such as the GMRA. In collaboration with other industry trade associations, ICMA developed a standard form information statement which assists in making this disclosure. It is available on the ICMA website in the SFTR resources section. More recently, also in collaboration with other industry trade associations, ICMA published the Master Regulatory Reporting Agreement, MRRA, to document the terms under which voluntary delegated reporting and mandatory reporting under SFTR and EMIR will take place. Due to the similarity between the reporting requirements and timelines of SFTR and EMIR refit, and at the request of the industry, we were able to produce an agreement which will cater for both reporting regimes under a common front-end agreement with regulation-specific annexes bolted on, one for derivatives under EMIR and one for SFTs under SFTR. The MRRA addresses confidentiality, responsibility for accuracy and timelines of data and liability, for example, data exchange between parties, and parties have the discretion in the annexes of the document to elect and define the scope and application of the agreement, thereby tailoring it to their particular circumstances. The agreement is also available in the SFTR section of the ICMA website. The next headline topic is CSTR. There is a considerable amount of time being spent on this file at the moment as we amend some of our standard documentation to assist users in complying with the requirements and dealing with the impact of CSTR. My colleague Andy Hill will provide a deep dive into the regulation and the expected market impact in his presentation, but I would like to highlight that amendments are being made to two forms of ICMA standard documentation. The first being the ICMA rules and recommendations for the secondary market, so the OTC cash rules, and the GMRA in the form of a CSTR settlement discipline annex. In both cases, the industry has requested that we consider compliance as well as market impact. That is, that we gold plate the requirements of the regulation such that issues like price differential asymmetry on both buy and execution or cash compensation are resolved contractually. The industry have also requested that we consider various means by which contractual amendments can be made, e.g. bilaterally or via protocol. In addition to contractual tools to assist with CSTR compliance, ICMA is looking at the provision of legal opinions on the enforceability of such tools in order to assist with considerations under Article 25 of the regulation. These may take the form of interim updates to some of the GMRA legal opinions and new opinions on the enforceability of the buy-in mechanism of the ICMA rules and recommendations for the secondary market. There are large and active working groups developing these work streams, and we encourage broad market participation. Please do not hesitate to get in touch if this is of interest. Finally, I wanted to bookmark other headline topics which the ERCC Legal Working Group are considering. First, to highlight that there is an FAQ on Brexit in relation to the GMRA available on the ICMA website. We intend to update this once there is further clarity on next steps. Second, I previously spoke in this forum about the ERCC-sponsored project to develop initial margin pledge documentation. The plan so far has been to focus initially on the development of pledge documentation only for initial margin, and to subsequently, if there is a need, develop a security interest agreement. Based on the latest market developments, members expressed a preference to reverse this approach and to prioritise the security interest agreement, given that this would seem to provide more immediate benefits to the industry, particularly in jurisdictions where netting is not enforceable. This work is now underway. Third, as we continue to monitor repo tech innovations, we are discussing hosting GMRA documentation on a negotiation platform. It provides an interface for negotiating documentation in a digital format, allowing for data capture in relation to the GMRA documentation. It has been designed specifically for amending documentation with respect to initial margin requirements for derivatives, but the aim is to build it out to a wider scope of industry documentation. We're in the process of assessing market interest at present, and please do get in touch if this is of interest. Finally, as mentioned earlier, we are pleased to add Argentina to the list of jurisdictions covered by the ICMA GMRA legal opinions. There are a number of other jurisdictions in which we are closely following developments, and in some cases have been able to provide guidance on developing standard documentation in line with the GMRA. So please watch this space for more developments. Lastly, I would like to thank you for your time today and encourage you to stay in touch with ICMA via email or phone, particularly whilst we find ourselves working remotely. Please stay healthy and safe.